Good morning, Uganda. Welcome to the show. In case you're just joining us, and for you who started the show with us or found us midway, you're still welcome, and thank you so much for choosing UBC TV. But if you're just joining in, this is Good Morning Uganda on UBC TV, and it's time for the agenda. Welcome back from the business desk with Robert. Now, this morning, we are looking at the Computer Misuse Act as amended 2022, whose really legalities were ruled against by the Constitutional Court last week. It's a conversation that's exciting many Ugandans, especially those who depend and use the internet a lot. But let's dig deep into it. Now, these were basically, this act, first and foremost, it was ruled against. The key provisions of the act as passed by the Parliament in 2022 were ruled against by the Constitutional Court, and basically added strict rules to this amendment, where criminalizing of sharing false, malicious or malicious unsolicited information. There was a banning of hate speech online. There was a restriction on sharing information about children without consent. And of course, introduced an introduction of heavy penalties, including fines, jail, and bans from public office. Now, the reaction to this amendment 2022 from many was that it was too harsh and would silence criticism. If you hear the provisions that were amended therein, you'd think they make sense. However, public opinion, and to many, these restrictions or provisions were rather harsh and silenced freedom of speech. Now, to have better insight into this conversation and the nullification as well as the law itself, we do have it's Isiko Arthur, who is the treasurer of the Uganda Law Society. My name is Julie F. Nantaba. Be part of the show, 0709-602-592. By text, WhatsApp, share your opinion, share your question. Let's learn and relearn together. Good morning, Isiko.
Morning to you, Ms. Julie. Thank you for hosting me on Good Morning.
All right.
Good morning, our viewers. My name indeed is Isiko Arthur, the treasurer of Uganda Law Society. Our president is Isaac. When I heard you say Isaac,
yes,
I thought
I know.
to mention the
My bad.
But it's okay. Our president is called Isaac Chimazese Makade, and he sends greetings to the entire legal and Ugandan fraternity.
Right.
Yes.
I'm definitely excited for this conversation this morning, so I encourage you once again, yes, be part of it, 0709-602-592. And let's start with the overall reaction as the Uganda Law Society.
Yes.
What do you think about the court's ruling regarding this?
Uganda Law Society, it's a win for us. Of course, Uganda Law Society is a body that joins all the lawyers in Uganda.
Right.
And as per Section 9 of the Uganda Law Society Act, it gives us a mandate to advise government and advise the public on all matters that are related to the law and incidental to the law. And of course, when the amendment came out in 2022, the first entity that went to challenge that act, the Computer Misuse Act as amended in 2022, was the Uganda Law Society. We are among the first institutions that challenged. We thought it was a bit harsh. It was really rushed. Yeah, the mode in which it was actually passed by Parliament. We believe it was rushed, harsh, and so broad. It couldn't actually enable the common person to understand his or her limits, and that is why, as a Uganda Law Society, we took this matter to the Constitutional Court. The Constitutional Court is the court that actually determines interpretations concerning the Constitution. The Constitution was put into place in 1995. It actually gives us, it streamlines, yeah, all laws. It is the supreme law. All laws derive their authority from the Constitution of the Republic of Uganda, and any law that is repugnant or that it doesn't align with the Constitution is null and void. And in fact, when we went to court, we said this Computer Misuse Act as amended in 2022 was not aligning with the Constitution of the Republic of Uganda.
Right.
Of course, the Constitution gives quite a number of guidelines when it comes to rights of citizens. It does break them down, especially in Chapter 4. And one of the rights in this particular case that we felt was being infringed on was the right to express, how someone can express him or herself. We also felt that the right to have an opinion was also curtailed in one way or another, and that is why as the Uganda Law Society, we really went out to the Constitutional Court and we put our arguments on table. We are saying there was a rush in how this law was brought about, because we do believe that issues concerning quorum, issues concerning civic participation, because at the end of the day we felt that the public should have been actually involved, especially those persons who are always involved in usage of social media. Right. You do realize that this act was just amended. There was a law that was in place, the Computer Misuse Act of 2011, and it has always been in place. Of course, with the developments that we have, the rise in new media platforms like Twitter, TikTok, Instagram. I think the parliamentarians and the policymakers, the executive, felt it proper that they should regulate, which was a good thing. Regulation is always important because we do believe that the digital space is always evolving, so you can't have an old law managing current affairs. But as the Uganda Law Society, we say that that is okay as long as the Constitution is respected. We should respect the Constitution. Right. And in that Amendment Act of 2022, the Constitutional Computer Misuse Act of 2022, there were very good provisions in that act. For example, forbidding the sharing of pictures of children. That was something good. Sometimes sending unsolicited information. That was something good. But we felt that there were some other offenses which were too broad. For example, offensive communication. We thought that was a bit broad.
But it's relative.
Yes, it is relative. It depends on who. If you look at the ingredients or the elements for someone to prove that case of offensive communication, one of them is disturbing the peace of probably someone. So we thought that such issues were issues that probably Parliament should have tried as much as possible to do extensive research, especially benchmarking on some of the treaties that govern Africa, like the African Charter on Human Rights. If they had benchmarked on the African Charter, probably they would have come up with a better law. So that is where, as Uganda Law Society, when the Constitutional Court came out through the ruling of Justice Irene Mulyagonja, who gave the leading judgment, we felt that it was a win, not only for the lawyers, but a win for the general public. And we believe if changes are made in light of the orders and directives of court, I can assure you we are going to have probably a better law if they have come up with a better law, because I believe the ministry that is in charge of coming up with such laws will come up with a better law that will actually benefit the entire public.
And thank you very much for that preamble. The fact that the Uganda Law Society is for this, one now would wonder where the checks and the balances, when is it overboard, when is it balanced? Therein, I'd like for you to just simplify in simple terms. What exactly did the ruling mean for an ordinary Ugandan in simple terms?
Yes, for the ordinary Ugandan out there, you should note that the Constitutional Court came up with the following orders. By orders, I mean these were the directives that were given by court. First of all, it annulled the provisions in the amendment. Like I said earlier, they amended and put in new clauses. And one of the clauses I've been mentioning about, for example, sharing of all those offenses. Sharings, sending, offensive
hate speech.
Yes, all those provisions that were put in the amended act were annulled. By annulment, I mean they were declared unconstitutional, meaning those provisions were unconstitutional because, one, the procedure that was used by the Parliament when enacting this law, court felt it proper that the proper procedures were never followed. Why? Because there was an issue of quorum. Quorum basically means that there is a certain number of members of Parliament who have to be present in Parliament before a law is passed. So in this particular case, that number wasn't available. So by virtue of that order of court, it said, since you didn't follow the procedure, on that alone, they annulled all those provisions that were put in the Computer Misuse Act as amended in 2022. So the effect is that, one, there were ongoing investigations. People had probably filed complaints, and the complaints were falling within that docket of the Computer Misuse Act. Probably someone shared your information, someone probably sent information that had an impact of demeaning you, that probably makes the general public think otherwise about you. So all such complaints that were filed against any person in this country by virtue of that order were terminated.
Wow. So in simple terms, that means all these, many of the TikTokers that we've seen being arrested are facing the law, those who have reported them. As we speak right now, whatever was going on has been cancelled.
Has been cancelled.
What about those who are probably behind bars as we speak? So
those who are probably behind bars, right now what they have to do is they have to get production warrants. Because you will find that probably some of those persons, your matter was adjourned, let's say in April, in May, but over offences in this act which has been annulled. So what you do as a person, you need to make a production warrant. So such persons who fall under that category, who are in incarceration or who are on remand, especially those who haven't been sentenced, I want to make that very clear. You are behind the bars, but your matter is still under trial, meaning they are going to listen to your evidence, listen to the other person's evidence, and then court makes a decision. In other words, court hasn't made a decision. So all those persons who are under trial and they're on remand and court hasn't made a determination over that matter, you can always make a production warrant. It's an application. You can always apply for a production warrant, and you're brought to the court nearest date. Assuming you are active enough and immediate last week, probably some of them will be arraigned in courts of law today, Monday, or this week. So all such persons, as long as you bring it to the attention of court, the charges under which I am being tried were annulled by virtue of the constitutional decision in the Constitutional Court. By virtue of that alone, court will have to terminate. It will have no choice. Court will have no choice because this case is now judicial notice. It is known by all. We assume that court is aware. We assume that the court is aware, so by virtue of that, they will have to terminate all those trials, meaning such persons will have to be set free, and probably their liberty they will regain their liberty in short.
Now,
any payments?
You will forgive me, just to still stay there. Usually, when you've been convicted before, if you're a convict, there's, as life goes on, there are those questions of, have you been a convict before? Have you? So with someone who is facing penalties for this particular crime, do they still carry that on their tag?
Yes. By virtue of this law, if probably your matter had already been decided by a court, that means at that time, the particular offense was committed and the law was still active. So right now, for such people, they face a different scenario. But you can always appeal. You can always appeal such decisions. I always tell people that the law is not made out of stone. If court makes a decision, probably in a lower court, let's say in the Chief Magistrate's Court or in the High Court, you can always appeal to a higher court, and always the higher court can always find or see the law differently. And some of the questions which probably might come into play are such issues, but for their case, it is probably a different story. So for those, like I've said, they have to follow the appellant process, where you can always appeal to the higher court. Yes.
Thank you very much. We're having a conversation with Isiko Arthur. He is the treasurer of the Uganda Law Society, and we're looking at the Computer Misuse Act as amended in 2022, and the Constitutional Court nullified the key provisions of the Computer Misuse Act amended in 2022, and that was last week. So it's what we are delving deep into to understand the facts and maybe the lies that you could be following and need to be corrected. Be part of the conversation, 0709-602-592. So far, a highlight for me that stands is the fact that if you've been facing these charges right now, you should be as free as possible because it's illegal that you're facing them, but also the fact that you should go through the right procedures. For example, having is it called a procedure warrant?
A production warrant.
Production warrant. in case you're on remand and you are asked to come back to court, maybe in the next month, your comeback should be pulled a little nearer so that at the end of the day, you're set free and live life as a Ugandan. Let me just read one comment from a viewer, and then we continue there on. I ask about the rampant use of AI on various social medias. How is it going to be handled? Very interesting, that one is.
Yes.
Do you think it's also covering, it's covered in the law, the rampant use of AI?
Usage of AI is not a criminal offense. Usage of any application that assists you in probably taking a decision is not a criminal offense. Right. So people who are using AI shouldn't get worried that you will be arrested anytime soon, or in case they come up with a new law, probably it might forbid. Yes. Yes, but of course there are professional standards, especially among in our practice as lawyers, the judiciary. There are always guidelines on how you should what are the limits on which probably you can benchmark on AI. So there are always those limits, but it is not a crime to use artificial intelligence.
Right. Yes. Now, back to the ruling of the Constitutional Court, the fact that quorum is one of the reasons that is cited there. Where does that leave the credibility of the legislative arm of the country? Yes,
that is now it brings, of course, questions on the procedural legitimacy of not only this acting issue, but probably also acts or laws that were passed in that duration of time. This might be just an eye-opener. Right. It's an eye-opener. Of course, like the Constitutional Court said, we have always been having that tendency of the yes and the no's. Yeah, when they're passing a law, probably the Speaker inquires in the status of those who are in agreement with the law, and those probably who have a different direction. So we believe that now that is going to change. That analogy where probably legislative officers sign in their tendency, because in this particular case, the one we're talking about, there was a register book. Okay. Yeah, people come on the day when probably a law is being debated about, and they say in the register book, but physically they're not present. Yeah. Oh. Yes, they sign in the register that we are attending, but in reality, on the day or at that particular time when the law is being debated about, it is a no-show. Yes. So God said, relying alone on the register book is not enough. Physically, they have to count. And by physical, they have to know that Isiko said ABCD and any other person. So if it is a yes for party A, it is recorded that so-and-so said a no, so-and-so said a yes. So now that is going to, one, increase on transparency. Yeah, that will increase on transparency and accountability at the end of the day. Yeah. Because now it is no longer a blanket registration. Initially, it was a blanket registration that we assume the yes had the day, or the no's had the day. Now it is going to be beyond that, and that means they'll have to improve on their discipline as far as passing, passing of laws is concerned. Therein, one would also wonder what message does it send in regards to adhering to the Constitution as the legislative arm of the country? Yes, of course, that takes me back to Article 2, which says the Constitution is the supreme law of this country. That is constitutionalism. Yeah, at least constitutionalism in this case has prevailed, because now you can clearly see that anything that is done that is not in line with the Constitution is automatically declared null and void, because the provisions of the Constitution are quite clear on the procedures that you have to follow when probably passing a law. If you don't have quorum, it tells you specifically through the rules that come there under that probably you can seek an adjournment for 15 minutes. Yeah, and a session is going on and you don't have quorum. If you realize that you don't have quorum at that particular event when you're probably passing a law, you can always seek an adjournment of 15 minutes, probably to call and mobilize members of parliament to come and attend. If they're not there, you can always probably adjourn until any further notice. But that just shows one thing, that the Constitution has prevailed. Right. Because the provisions of the Constitution, once not followed, automatically renders whatever has been decided null and void. I think that is in light of the fact that all powers derive from the people, and the parliamentarians represent people.
The people, yeah.
So if they're not in parliament, then how are the people being involved or represented in whatever is going on? So that just shows that constitutionalism at the end of the day prevails, and it is a lesson to parliament, and especially those who are about to go into the 12th parliament.
Indeed, I hope it is a lesson.
I hope they really need to read this law, this act. I mean this constitutional judgment that was made. They really need to read it, internalize and understand. I believe once they do that, it will make their work very easy in the 12th parliament.
Right. My name is Makerere Adimon from Kasese Municipality. It appears to me that the proponent of the Computer Misuse Act was stimulated by the social media rants about him. Who? So an MP, he used his position to cause legislation, to curtail people's constitutional freedom of expression, thanks to the Constitutional Court. All right, Admon, thank you so much for your contribution to the show. Be part of the conversation. We are looking at the ruling of the Constitutional Court as of last week, where it nullified the key provisions from the Computer Misuse Act amended 2022. Some of these provisions that are now as illegal as possible, according to this ruling, are sharing false or malicious information, unsolicited information. At that, it was a crime by that act, but right now it's been nullified. Banning of hate speech, restricted sharing of information about children without consent. Right now it's also as open as that. And of course, heavy penalties were introduced. Also looking at offensive communication. How broad was it? What was it relative? Was it absolute? All those were questions that the Uganda Law Society was trying to tie the bolts in there according to the provisions. As we speak right now, the provisions seem good. They are good if you ask under normal circumstances. But the basis and foundation from which they were bred is what has a lot of questions and brought the Constitutional Court to nullify them. Ask that question, share your opinion, and at the end of the day, learn something and put it in practice. Let's learn and relearn together for the better of our country. At that, now, Isiko Arthur is one we're having this conversation, just in case you're just joining in. He's a treasurer of the Uganda Law Society. Now, let's look at accountability. Do you think that the parliament, that there should be some form of accountability or action taken on parliament to, I don't know, maybe answer for this?
Yes, I believe, of course, we, the members or the citizens of this country, you can always call upon your member of parliament to account, to give you a clearer picture. But of course, there is immunity. There is no way you're going to charge a member of parliament for not attending that particular day, or probably the Speaker of Parliament not following or confirming that indeed the quorum was there. They have that immunity in the performance of their duties, even if they make an error, because errors are human. They have the immunity. Otherwise, people will be fearing to go to parliament, that in case I make a mistake, automatically the following day I'm going to be arrested, and probably cases of abuse, office abuse are probably slapped against me. So they have immunity, but this should be a learning. This should be a learning lesson. Of course, there are Ugandans out there who might think now it is an open gate. Now let's start sending pictures of young ones, without probably getting consent from their parents or from their guardians. Let's start sending information, unsolicited information to people. There are other laws in place. A Ugandan out there should understand that even the fact that this law has been annulled, we still have other safeguards. We have a constitutional safeguard which gives privacy. It is a right of a citizen to have their privacy. You can't infringe. When you infringe on their privacy, you take a picture without their consent. You are infringing on their privacy. So with or without this law, once you do that, you are automatically infringing their constitutional right. We also have other laws like the Data Protection and the Data Protection Act. Yeah, it is also quite clear. It really says that there is no way you can take information or share information of anyone without their consent. And I think that's the law that actually governs, let's say, telecommunication companies, media entities. Yeah, there are still safeguards. Yeah, impersonation. Someone gets a picture, your picture, then probably they use it as their profile, and they start probably sending out information, saying, I am so and so, please do A, B, C, D.
I think that also speaks into what somebody was asking about, the rampant use of AI, where people get other people's pictures and plant them in scenes that are not really there.
Yes, it is an offense. Yes, impersonation. You're trying to impersonate probably someone and maliciously or falsely obtaining something. Yeah. So the law still protects, we still have such laws that protect people. We have the Electronic Signatures Act, the Electronic Transactions Act. All those laws are put into place. And I think that is also one of the issues that we brought out, by the way, as a Uganda Law Society. We thought that this act was more of a duplication of already existing laws. The already existing laws which are safeguarding the citizens of this country. Yeah, so we thought it was a duplication. Of course, we understand the fact, like I said, that there were some new provisions which were not anticipated. Remember, the other laws, especially the computer issues, was of 2011. So by 2022, there are so many changes. Yeah, but that should have been limited to the changes, yeah, not a duplication of already existing laws. And also some of the punishments were really harsh.
Yeah. Do share some of these punishments and why you think they were extremely harsh. Just an elaboration for an ordinary Ugandan. Yeah,
of course, like for example, some of the offenses are criminal libel. If you look at the Computer Misuse Act, all the offenses under that Act of 2011, yeah, the punishment was between 1 year to 3 years. And of course, the punishment is meant probably to teach you. Yeah, it is meant to reform you. Yeah, it shouldn't be so excessive in a form that no longer serves the purpose. Yeah, so coming up with a punishment of almost between 7 to 10 years, because the amendment now gave a punishment of 7 to 10 years. We felt that was so harsh. Yeah, we felt that was so harsh, especially, of course, ignorance of the law is not a defense, but there are people out there who probably might put a picture of someone. Yeah. Imagine you put a picture of someone, he takes you to court and you have to serve 7 to 10 years. And yet there are other offenses which are even, if you look at the gravity, yeah, it is so high. For example, theft, yeah, and you see almost it is the same. Yeah, someone steals government funds, yeah, and they also have suffer repercussion between 7 to 12 years. Then someone probably shares, and then they also have to suffer. So we believe the offenses were, the punishments were so stringent in nature. They should, if they are coming up with changes, especially if the parliament thinks that this law should be brought back, they should try to reduce on such punishments and probably make them a bit lighter and try to do a comparative analysis. You know, this act here is not it's not new only to Uganda. Even other countries have such acts. They may not be called the computer misuse per se, but they are out there in other countries. They can benchmark and they can actually see the picture out there, and probably it can help them in decision making.
Right. Yes. Let's look at how this new ruling affects journalists, social media, maybe influencers, bloggers, all therein. What does it say to them? How does it speak into their area of operation, and how does it affect them altogether?
The beauty with this ruling, or the decision that was made by the Constitutional Court, it has now expanded the scope of work. Yeah, you will no longer have limits, those limits that were there initially. For example, if you are to take a picture, or if you are to share certain information about any event probably happening, or any fact that is happening anywhere, in this country, for example, you are following up on traffic. Yeah, now the law with this annulment, that means you can actually do your work without so much restrictions. Yeah, you can easily capture information that is happening on the road and probably share it to the general public without fearing that probably if you capture someone therein, you're going to face repercussions. That was a win. When it comes to offensive communications, especially journalists, you might have to make opinions without that fear that probably if I make a comment, if I give a perception, it will be considered offensive. Probably someone might be hurt, and that might probably lead me to court to answer such charges related to such communication. So this is a win for journalists. It has widened their scope. And secondly, now in case there are some changes in front there or in the nearby future, I believe that now they will even be more clear. Yeah, the spaces will be more clear. Journalists will have to know these are our boundaries. Initially, they all didn't have boundaries, that these are the boundaries within which, this is the limit within which you're supposed to probably make a comment. How offensive is that comment? So all that now will be, at least to believe, it will be captured well in the new law, and probably if it is brought up, might actually assist in the journalists doing actually their work. And there was also something where we felt that there is need to probably look into it, the issue of extraterritorial jurisdiction. You see, when you read the law, it says that the jurisdiction of courts sometimes is limited to activities that are done within the country.
Right.
Yes.
Right.
If you are driving a car in Kenya and you commit a traffic offense, our courts here, can't actually charge you.
Charge you of anything.
Yes, of such cases, traffic offenses that you did in Kenya. Yeah. So this law, the one which has been annulled, had that impact that if you committed misuse of the computer out of Uganda, you could still be tried in Uganda. Meaning if you misused the computer there, if you started sharing information out there when you are in Kenya, that probably affects the citizens of this country, you will be charged
in Uganda.
here. You will be charged here in Uganda. So that is a law, that is something we think that to also have to be looked into, because laws are territorial in nature. For those who do, I said there was a program of business, trademarks and copyright, etc. The protection is limited to your country. You can't say you own a mark, and then you want it to be protected outside of Uganda. It has to be protected only within Uganda, within the boundaries. So that is something we think has to be looked into, and we believe it will make the law a bit better.
Right.
Yes.
Thank you very much. And as we begin to close this off, let's just handle one question that comes through from Isaac Wanzala in West Nile. He says, Mr. Isiko, how best can a law help me when someone hijacks my social media account and start conning or posting nude pictures on my account? That's the question. Yeah, that is the impersonation I was talking about. The Penal Code Act, which talks about impersonation, can always save you. You can always make a complaint at the nearby police station that so-and-so is impersonating me on my account. I can assure you, by virtue of that complaint, such investigations will be done. Probably that person will be apprehended and taken to courts of law to explain why they are trying to use a picture and probably con people, because that is even fraud in its very nature. Obtaining money by false pretense. There are so many offenses that person can be charged with in case is apprehended. Obtaining money by false pretense, impersonation. So you can be protected. That's what we are saying, that even the current laws as they are, they can protect you. They can protect any person against someone who is illegally using the computer or electronic gadgets. And by computer, I don't mean this desktop or the laptop. Even your phone is a computer. That recorder that you have out there is a computer. So the definition is so wide for a computer. Right. Now, your parting shots, especially as a message to Ugandans, with the rights and responsibilities we have after this ruling, what parting shots do you have?
The parting shots I have for Ugandans, one, please kindly note that Freedom of expression is a constitutional right. It is given to you by the Constitution of the Republic of this country. But however, please use it sparingly. You shouldn't use it to the detriment of fellow Ugandans. Freedom of expression is a cornerstone of any democracy. You can always gauge democracy of any country by probably looking at how people can freely express themselves, how journalists are being treated. You can just look at it and probably gauge the democratic levels of any country. So I just employ Ugandans to be law-abiding citizens.
Right.
Yes.
Thank you very much. That is Isiko Arthur. He is the treasurer of the Uganda Law Society, and he's been simplifying the ruling of the Constitutional Court as of last week, where the Constitutional Court nullified the provisions, key provisions of the Computer Misuse Act. Hopefully you've got something out of it. Up next is Ruben, and I know he has a lot to say about Arsenal, but oh well. It is what it is. Have a good morning and be blessed as you enjoy the sports update. Good morning.
All right.
Live from UBC Studios in Kampala, this is Good Morning Uganda.